welcome to the second session of this conference. First, I would like to join the previous speakers who thanked and praised Ariel and Rabbi for the wonderful job they have done in initiating and organizing this conference. The topic of this session is alternative means for collective dispute resolution. As a general comment on the situation in Israel, we are here mostly familiar with one of these means, mediation, and I'm talking in the context of class actions. And based on my experience as a practitioner, it is becoming more and more common to channel class actions to mediation proceedings, especially in complex cases. It usually serves the interests of all parties involved. It serves the interests of the plaintiff who seeks for settlement sooner than later. It serves the interests of the defendant to hedge the risk and reduce legal costs. And it also serves the interests of the court system, which is overloaded. However, the success of mediation proceedings does not necessarily guarantee that the proceedings will end. Under our class action law, a settlement agreement is always subject to the review and the approval of the court, which may, of course, decline to approve it. Therefore, in many cases, parties choose to appoint as a mediator a retired judge. Naturally, they expect that a reputable retired judge will be able to present before each party the risk and the chances in a genuine manner and lead the parties to a fair settlement. Just as important, they believe that this would be the assumption of the court when the settlement agreement is submitted for its review and approval. While the vast majority of settlement agreements reached in mediation proceedings have been approved by the courts, there are some exceptions. In the decision rendered recently by the district court in Lod, the judge refused to approve a settlement agreement in spite of the fact that it was tailored by two highly appreciated mediators, retired Supreme Court judge and a prominent professor from Tel Aviv University. As I mentioned, and as you are aware, our law is young, and so is our experience, and it will be therefore very interesting to hear from the participants of this session about various alternative means which have been developed in other jurisdictions. The first speaker in this session will be Professor Janssen, who will try to answer the following question: how to combat trifle damages in consumer mass disputes. Janssen is an associate professor at the City University of Hong Kong. He has previously held positions at the universities of Bayreuth, Göttingen, and Münster in Germany. Furthermore, he was, with the support of the European Commission, a visiting scholar at the universities of Nijmegen, Oxford, and Turin, and member of several research networks. He published more than 100 books and articles in the field of private, European, and comparative law. The latter, that deals with preventive disgorgement of profits, was awarded the Marie Curie Award in 2015 by the European Commission. Andre, please.
Okay, I'm too tall for this mic. I will do my best. So, my title, How to Combat Truffle Damages in Consumer Mass Dispute, Maybe at first sight you might know, well, why I'm at all in that panel or on that panel, and I hope you will see in hindsight why I still think that this is the right panel. So what was interesting that this morning, I think every speaker talked about a little bit, at least, about truffle damages. So what are truffle damages? There are, first, maybe when it comes to the terminology, we should know that there are different kind of terminologies, just to set it right. So there are scattered damages, truffle damage, trifling damage, sometimes also called nominal damage. So what are they, these kind of damages? So this is a loss. The individual consumer has a very small, maybe even marginal loss. But as this is, as there are thousands of consumers who have this loss, the wrongdoer can maybe get a huge profit, and that might sum up to millions or millions of euros. And what is the core problem with that truffle damages, if we just try to put it in a nutshell? And that's actually, that's rational apathy. That's the rational apathy of all of us. We are homo economicus. If it's not worth it, we are not doing it. If it's too much of a hassle, so we have a particular amount. If the amount is just too few, we don't start any proceedings. It's just like that, and we are not machines. So this is why we do that. And so the European Commission, where do truffle damages actually start? So what is the amount? Of course, we don't know actually 100%. It differs on the persons, it differs on the circumstances. The European Commission said in one green paper, more or less around about 200 euros, which would be 800 shekel, I think. I don't know whether this is true, but it's not. But that's just maybe like a rule of thumb. And so, how do we combat that kind of rational apathy of all of us? How can we try to make things better? Well, we could start, of course, trying to adjust the private law mechanism. We could try to increase the incentive to sue. And how can we do that? We can do that we can try to do that at an individual level. And the individual level, what can we do? We could try to, well, we could think of damage multipliers. We could think of punitive damages. We could do that. That would increase the incentive to sue, definitely. But we are, at least with seeing it through my European glasses, we are not very big fans of damage multipliers, of punitive damages, because it has a lot of legal problems. So it would be a solution, but legally speaking, at least with my European eyes, there are a lot of conflicts. Well, bringing it to a collective level, we could do that, yes. The problem is if we do an opt-in, it doesn't help us very lot, because the incentive to sue is nevertheless still not there. Maybe it lowered a little bit, but if you're not suing for a few cents, a few euros, you just don't do that. And an opt-out, yes, we can do that. I think we just talked that in Israel they have an opt-out system. The Europeans have also here a lot of legal problems with the opt-out system. So we are skeptical that this is the right way. So also at least problematic, the opt-out system. Then ADR, yes, might lower that might help a bit. But again, if it's too low, it doesn't work. It doesn't work. If the sum which you could get is too low, then also ADR is a problem. And so what can we do? So obviously the private law is at least the pure private law has some problems, we could think of, like Chauvel said, well, bring it to the public law level. This is where trifle damages belong. It's public law. And they have the instruments, confiscation, maybe fines, and so on. So the instruments are there. The problem is, what we all know is that the public law enforcement agencies, they have some problems. If we are thinking that the private law, that the enforcement of public law is the right choice. So the lack of information, they have limited sources, they must prioritize, and maybe they don't maximize always their enforcement efforts. At least that is what the law in economics says. And in addition, if I'm talking to administrative law guys, they are telling me, no, don't give it to us. It doesn't belong to us. That's an erosion of administrative law. Please don't give it to us. Then we could think, okay, maybe the criminal law persons. So, and they are starting directly, no. Criminal law is ultima ratio, and you are trying, the private law persons are trying to do it prima ratio. That does not work, and that's an erosion of criminal law. We cannot help you. So obviously, what we see is, let me see. Okay. Obviously, also the public law has problems to deal with trifle damages. And so now is the question how we could just say, well, obviously we could have a nothing works mentality. Obviously, trifle damages are very hard to handle, and we just have to accept that. Of course, that would not be the best solution. So couldn't we find another way? Couldn't we find to go for a sort of legal hybrid, which has public law elements and private law elements, putting them together and trying to make the best out of it? So this idea of creating legal hybrids to combat trifle damages this idea is not new. And so we have the German legislator introduced in 2004 such a solution, a sort of so-called legal hybrid, and that could maybe a starting point for a good discussion, and we will see whether it works. It has been in force for 13 years now, so that should be a good idea to reflect whether these kind of things work, whether a legal hybrid could really be of an help. And so this is, so section 10, that's the only article I'm going to discuss, of the German Act Against Unfair Competition of 2002. We have a similar provision for the cartel law, for what we understand under cartel law. Whoever, while acting with intent, engages in an illegal commercial practice, thereby making a profit to the detriment of numerous purchasers, can be sued for surrender of such profit to the federal budget by those entitled, and by those entitled are consumer agency, among others. And this is a very interesting provision. It was in 2004, it was very much discussed whether this is a good solution or not. And personally, I think it has some good ideas and some very bad implementations. So the idea is consumer agencies can disgorge the profits of the wrongdoer, but they have to surrender it to the federal budget. And the good thing, I think, this section makes clear that it's not about compensation. It is about prevention. That is, at least the legal nature is very clear. They say prevention first and compensation as it is trifle damages, and normally the consumers, they're not interested anyway for a few euros. Let's do prevention. Also, the legal sanction is clear. It's disgorgement of profits. That is also clear. That is a positive aspect. And it is clear that the consumer associations should have the right to sue. These are, I think, positive aspects. The problem is it does not work in practice very well. We have like, so it's 2040, so it was introduced in 2004, now it's 2017. We have just a few dozens of decisions. Why is that? You could think, well, this is such a very good preventive instrument, so all the market members or every market participant is just behaving perfectly. So and this is due to that very nice section. I think that is not the case. We have to be honest. And they have this provision has, I think, two very negative aspects. The first thing is there is a very high subjective threshold, and which is intention. Intention of the wrongdoer. And the consumer association should prove that. And that is something which is very hard in practice, and the consumer associations struggle to prove the intent of the wrongdoer. And then, maybe even worse, is that, so they are fighting, they are doing all the way. They decide, okay, we are suing another company, and what they get is they have to, so even if they win, they have to surrender 100% of the profit of the wrongdoer to the federal budget. But if they lose, in Germany we have the loser pays it all principle, they have to pay. And if you know that consumer agencies, normally they are not sitting on money like Dagobah Duck, so it's just, if it does not work. It does not work. They don't have any financial incentive to do that. And it's risky. For some consumer associations, they just cannot do that because they would be at risk. They would be bankrupt. So that does not work in practice. So these are the two main problems why we just have comparably few decisions on that sections. So to make things better, what could we do? In general, is to lower down the subjective threshold. So, well, intention of the wrongdoer, very hard to prove, so that we should lower it at least to gross negligence or even negligence. That could be one solution. And another solution, another idea, which is, I think, even more important, is that somehow the consumer associations must have a financial incentive to do that. And the first one could be a direct participation. So they would get some part of the profit at least. Or indirectly. So there would be, we could set up a foundation, and this foundation then again finances that kind of claims of the consumer associations. That would be two things to make things, two aspects which should definitely be improved. And these are, so to summarize this, I think that trifle damages are indeed a problem. They are a big problem for the society, and that we should try to do our best to avoid them or to combat them. The problem is the core problem is the rational apathy of the consumers. The public law itself can be of an help, but it's not the solo ratio. I think it must be a sort of policy mix. And personally, I think that the idea of a legal hybrid is at least, it should be discussed, whether that is a good idea. As you see in the German example, that is, I think, it is not a paper, well, now it's more or less a paper tiger, to be honest. But we could make things better, that it works, that it would be more efficient. And so maybe that is a good starting point for further discussions. So thank you very much for your attention.
Thank you very much. This is definitely the tallest panel here. The next speaker, Diana Wallis, whose unique experience combines academy and practice. Diana originally trained and practiced as a solicitor in London, specializing for many years in cross-border litigation within the EU. In 1999, she was elected to the European Parliament, where she became a prominent member of the Legal Affairs Committee, authorizing a number of key legislative reports in the area of civil and commercial law. She was also a vice president of the Parliament from 2007 until 2012, when she resigned. Since leaving the Parliament, she has trained as a mediator and arbitrator and is a senior fellow of the law school at the University of Hull in England. She has a number of roles in connection with various organizations related to European law. However, her principal activity over the last years has been as president of the European Law Institute. Diana, the floor is yours.
Thank you very much. Thank you for the introduction, and thank you very much for the invitation. It's really very appreciated, and even doubly appreciated, I should say, because I'm organising my own conference back in Hull in 2 weeks' time, and I'm panicking. So I'm glad to come away for a few days. But also glad to note the nature of this conference of bringing together both scholars and practitioners, because that is very close to the model which the European Law Institute recognises and embodies in order to try to bring together the community of lawyers to improve and develop European law. And I think it's interesting that one of the very first statements that we ever produced was actually a statement on the European Commission's recommendation on class actions, although the title's a bit different to that, but you all know what I mean. So this is a subject that has fascinated the European Law Institute, and indeed today I've been asked to speak about ADR and class actions, and at the moment we are engaged in another project about the relationship between formal justice in the courts and informal justice. And that's crucial that going forward, I think, in all our jurisdictions, we get that balance right. And I will say very clearly at the beginning that I am pro-class action and I am pro-ADR. And there does not have to be any confusion about that or any contradiction. The two can coexist if you use them in the right way. But I want to start by a few observations about ADR and maybe about what consumers might expect or want from an ADR process. Because I think there is a lot of confusion about what ADR is and what it is in relation to class actions. But if we think of ADR in general, I want to be a bit anecdotal here and tell you of my own experience in working within 2 ADR schemes in the UK, because I think they can be illustrative. They concern mobile phones and funeral services. So very different. But in terms of telecommunications, in the UK, we have an ADR system called CISAS. It's a bit complicated, but all these things have acronyms. Operated by 2 private providers, subject to the telecoms regulator. And both of these providers, ADR providers, have operated historically different types of systems. The one I was engaged in was a purely paper system. So a consumer sends in a complaint, You as the adjudicator look at what the consumer says, you look at what the business says, and you write a decision. All you can do is ask for further documentation from either party. You cannot speak to either party. So it's purely a paper system. Now, obviously, the way you frame your written decision as an adjudicator can help people feel included and help bring them towards your decision. But I would say that's perhaps not the most satisfactory of ADR systems for the consumer. Conversely, the funeral services scheme that I was involved in is called an arbitration scheme, but actually what it amounts to is telephone mediation. In other words, somebody has a complaint against a funeral service provider. They go to the scheme. The conciliator or arbitrator receives all the papers and then picks up the telephone and goes to and fro between both parties. And in those circumstances, you are able to speak to the consumer, to listen, to go through a process with both parties, and hopefully at the end, they are more or less both satisfied. Now, why do I recount all that to you? Because I think process is important, and involvement of complainants in the process is important. And if you look at the work of a scholar at the time, Oxford, Naomi Kreutzfeldt-Banda, did some very interesting work on looking at these types of services in the UK, but particularly at one type of private ombudsman services. And her conclusion was that the process is all important. People are not so worried, or consumers are not so worried about the outcome if they feel that there has been procedural justice and procedural fairness, that they have been given a voice. So that, in a way, can be the beauty of ADR schemes when you've got what I would call an individual complaint, although, of course, it may be indicative of a pattern of bad commercial behaviour, but the consumer is being dealt with on a one-to-one basis, and better if they are actually heard in some meaningful way. But there is another observation I made as a practitioner being involved in these two schemes. And this was that over the longer term, you were doing yourself out of a job. Because actually what you're doing is training the company to act in a better way. You're working with them to almost improve their customer service, their way of dealing with things as you go through every case. And indeed, there's some evidence, particularly in the telecom sector, that these cases are falling off. And it's also happened with this funeral scheme because, as I say, there is an element of training the providers in using these forms of ADR. Now, I won't say that it means that everything will suddenly be perfect in the world. It won't. But I think it's also an interesting way of being preventative if you can have this sort of embedded ADR. But also, these two examples are examples of sectors, one where you have a regulator, and the other where you have a clear industry code of conduct which is enforced by the industry. So you have a sort of virtuous circle which ensures that things function between consumers, service providers, and some sort of enforcer, be it the industry itself or a third-party regulator. So, having looked at those sorts of ADR schemes, can we transpose that, or can we learn something from that in terms of class actions? My fear is this: in a class action scenario, you cannot give the individual consumer the same voice, maybe not the same sense of that procedural fairness as they can get in the individual cases. They are put into this mass. So I think we have to be very careful about the type of ADR we use in relation to class actions, because it's not clear to me that certain types of ADR might indeed be what was called class action killers, or at the very least they can turn out to be a form of ADR which maybe makes the consumers or a consumer group accept something less than that which they should be entitled to. So you always need a backup. The other thing I wanted to try to highlight as a way forward is the fact that certainly in a European scenario, we face a tension between ADR and class actions in terms of the legislation or framework that we have, because I would hesitate to call it legislation. And that's in this respect. We now have a European directive on consumer ADR. One of the things in that directive is a requirement on those entities who provide ADR to report on an annual basis the sort of repetitive behaviour that they see. Now, that's good, but of course the reporting is anonymous because the ADR process has been confidential. It's way out of date by the time it reaches anywhere where it possibly might be useful. And so one questions whether it is actually a useful exercise, but doubtless it still ought to be done. On the other side, in the recommendation to do with collective actions, we see the European Commission saying, oh, there should be some sort of registry about collective claims. It doesn't say where this registry should really be. I think it said it should maybe be national, but you really needed something European. So one of the things that we have, which I believe it could be a key to helping us find a way forward, is we have the sort of embryonic possibility of collecting information in two places, but we're not actually doing it in an effective way at all. And if we could capture that information in more effective ways, it might, A, help us be more preventative in terms of what is going on in the marketplace, and B, lead to more possibilities in people taking action together. But to conclude, what I really wanted to conclude by saying is that, a bit like the last speaker, I think you have to put two things together. In my case, I believe you can get positives from ADR and certain types of ADR, particularly ombudsman-type schemes. But I'm not sure that schemes like mediation and other methods work in mass actions, but ombudsman may. But you also need that partial regulatory or investigatory type power that certain ombudsmen have. And then you need some form of enforcement. And I think it's putting all that together that we need to concentrate on for the future. But just to say ADR, as many people did when we were trying to legislate for class actions in Europe and failed, to say, oh, do ADR instead. No, ADR is not an alternative to class actions. You need both in proper balance together. Thank you.
Thank you very much. Last but not least, Dr. Mateja Durovich. Durovich, right?
Yeah, correct.
I have to get it right. Who has arrived from the City University of Hong Kong as well, where he serves as an assistant professor of law. Dr. Durovich holds a PhD and LLM degrees from the European University Institute in Florence, Italy. LLM degree from the any problem? LLM degree from the University of Cambridge in the UK. He was a postdoc research associate at the European University Institute, visiting scholar at Stanford Law School, USA, and at the Max Planck Institute of Private International and Comparative Law in Hamburg, Germany. Dr. Durovich worked for the legal service for the European Commission as well as a consultant for the European Commission, BEUC, the European Consumer Organization, and the United Nations. In July this summer, he will be joining King's College in London. Mateja will tell us about various alternatives to collective redress.
By the way, I forgot also to, of course, to thank the organizers, which I did not do, so just to, so using the time.
Fantastic, eh? I never believe in technology. Huh? Okay. Good morning already. Good afternoon, ladies and gentlemen. Thank you very much, Itamar, for your very kind introduction. First of all, of course, I would like to say that it is my great pleasure and honor to be again here. I think I was discussing yesterday with Stefan Voigt. I think we are we are the only two people who actually, like one of you who have again arrived here this year, like after November 2015 and the end of very, very successful first annual conference of collective redress, which took place. Also, of course, huge, many thanks to the organizers, University of Haifa, School of Law, and in particular, of course, to Rabea and to Ariel, who did a wonderful job. And since we a bit, like also from the Hong Kong, we participated in the organization, I know how much time and how much efforts actually took them. I know how many times I would receive the calls because of the time difference at 2, 3, 4 in the morning, like, which is still here late in Haifa because Rabea and Ariel were working very, very hard. Again, it's very nice being again in Haifa and feel like being surrounded by all of you, like being surrounded with my family and friends, which is very nice. Thank you. So my presentation, the first one I will be speaking today because you actually condemned to listen to me twice this morning and in this afternoon as well again. The first presentation will actually deal as the subject of the panel is the alternatives to the different models of collective dispute resolution of consumer disputes. Basically, the major idea of my presentation, what I'm trying to say is what are the alternatives to the collective redress, because we could hear from the first panel this morning that actually collective redress is faced with different problems. In the United States, again, more and more difficulties and more obstacles, which is something we'll be listening more about probably later from the American colleagues who are experts on that. Whereas on the other hand, again, from the presentation from our European colleagues this morning, we could also hear that collective redress is true developing in Europe, but again, there are many different kind of obstacles. So the question is, what are these alternatives to different models of collective redress? And in that sense, of course, I will be talking about alternative methods for resolution of consumer disputes, which is certainly something that is now being really developing and being promoted as the best possible method for resolution of consumer disputes. And that's something that was also mentioned by the speaker before me, Ms. Diana Wallis. In that sense, I always like to quote Professor Gerhard Holz, who always says that consumer law is as good as its enforcement. So in that sense, it's always very important to have a good legal framework for enforcement in order to secure that that consumer law is not what is only law in books, what is law on paper, but what is also law in action, that different consumer rights which are being granted are actually enforced. And in that sense, the establishment and the development of an appropriate legal framework for enforcement and of consumer law, for protection of consumer rights, is actually one of the most challenging tasks of the consumer law and policy. Recently, we can actually follow the development of alternative methods for resolution of consumer disputes, which include different possible schemes. Of course, the most important one are arbitration and mediation, but also we have different types of ombudsman, conciliation, complaint bodies, which try to resolve consumer disputes in a more friendly and in a faster, more efficient, more approachable way to the consumer than the regular manners before the court. Again, some of course of the classical advantages, like arbitration in any case, include procedural flexibility, low cost, specialist knowledge of the adjudicators, and the possibility for speedy resolution of disputes. These are certainly some of the advantages, some of the reasons why consumers like to opt for ADRs. Again, some of the typically formal parts of the regular court procedure, including here collective redress, are also avoided in case of alternative methods for resolution of consumer disputes, such legal representation, rules of evidence, strict application of substantive law. In that sense, ADR allows us definitely more flexibility. Of course, there is not only advantages, there is also a problem, because now we have also tendency that different traders and industry themselves develop their own ADR schemes, where we have a problem with their really impartiality and independence, as they have been at least developed, or they are supported by different traders and industry. So the question is how to secure their impartiality and their independence, which is definitely a huge task. Also in some other sectors, for example, in the area of financial sector, we have very strongly promoted alternative methods for resolution of consumer disputes. But the question is what happens with the other industries where this is a bit more expensive and more difficult to do it. What is essential to underline always in case of the alternative methods for resolution of consumer disputes is this requirement of legality. Basically, that consumers shall always have also the possibility to try to protect his rights before the court. That in the sense that arbitration should not and shall not be the only way to actually allowed for resolution of consumer disputes, because simply of the possible detrimental effects on consumers that traders might misuse their power and their position simply and impose the resolution of disputes before the ADR. In that sense, definitely, like, we should always have a court and the access to the court in the sense that as always the last possible instance. So that's what's very, very important. again, legal certainties in the context quite important in the context of ADR, and that's something that Professor Geraint Hollis and I have co-wrote a paper on that, the achievement of legal certainty in the context of alternative methods for resolution of consumer disputes, because this is very complicated question, how we can guarantee legal certainty. In other words, how can we guarantee that consumer rights will be protected in an effective and a right way in case of alternative methods of resolution of consumer disputes. But this is something that definitely AD mechanisms, when they're developed, legal framework for alternative resolution of consumer disputes, always need to take into consideration this idea of the legal certainty. Again, the traditional criteria that always ADR entities need to fulfill are to be impartial, accountable, transparent, and operate in the interest of consumers. Definitely, me as someone who promotes, I know the interest of consumers is the weaker. I know that some of you in these rooms would not agree on that, but this is at least my in general idea. And in that sense, the ADR mechanism should always be developed in the context that it incorporates the interest of consumers and the fact that consumer is a weaker party in the relationship. So in that sense, consumer arbitration must be very strongly distinguished from the classical commercial arbitration, because the presumption in case of commercial arbitration is that the parties are more or less equal. When it comes to consumer arbitration, we have a trader and we have a consumer. Similar, likewise, analogy can be made with consumer contracts, where again, in case of commercial contracts, parties are more or less equal, so less regulatory intervention is needed than in case of consumer contract, where there is this strong inequality of the contractual parties. Again, in the context of what's quite interesting to mention of ADR, what could be, for example, defect in comparison to the classical collective redress is the fact that it is very confidential. Professor Miklis has mentioned, for example, this case of Apple. Well, the biggest actually damage that Apple has suffered from this case is basically its bad reputation. Of course, he was infringed a lot of money. But Apple is traditionally known as very consumer-friendly trader. Typically, it's not one of these who is known to be infringing the rights. But bad reputation is definitely something that traders are the most scared of. And that's actually one of the things with ADR, potentially a problem, because simply you put the problem under the floor, so no one can actually see it, no one can see what is going on. In that sense, the reputation, which is essentially important for a company, is actually protected. So this could be, in that sense, some kind of problem that even if we have a number of problems, a number of disputes, consumer disputes, that they can all be secretly resolved without any public disclosure, which can be a problem. Whereas when it comes to, of course, class actions, it's much more public. In that sense, context is, I briefly mentioned this. I'm sure maybe some of American colleagues will know it better. This idea of the American Arbitration Association, which has attempted to provide an adequate regulatory response to development of the AAA consumer arbitration rules, which are supposed to deal with collective disputes, the resolution of collective disputes, collective consumer disputes, which is definitely something to be interesting, and to see how in the United States, to be interesting to see how arbitration is actually connected with potential class actions. And this is something that certainly should and will develop in the future. To mention briefly the legal framework in the European Union, we have two pieces of legislation, one directive and one regulation, which deal with resolution of alternative resolution of consumer disputes. In case of both of these legal instruments, they are primarily focused on the idea of cross-border as the most complicated question of EU consumer law, of course, this cross-border issue, and especially how cross-border disputes are going to be resolved. You can see some of the, it's quite new directive, 2013, and some of the qualities, some of the characteristics, some of the criteria that ADR entities are required to have: expertise, independence, impartiality, transparency, effectiveness, fairness, liberty, and legality as the necessary requirements. As I told you, this primarily applies in a cross-border context, but definitely also will influence the development of the national schemes for alternative resolution of consumer disputes. The other piece of legislation is the regulation on online dispute resolution, which deals with one particular type of consumer disputes, those ones which have been arisen from different online transactions. So the idea is now to offer to consumer a possibility to resolve their disputes over also online, over the internet. So that is also the idea. That's why there is the development of one platform on the European level, whose aim is to, in order to help consumers and also traders resolve the disputes which have arisen online. Besides the European Union, we also have other legal instruments which deal and which also promote alternative methods for resolution of consumer disputes. For example, World Bank's Good Practices for Financial Consumer Protection of 2012, which is something that of course deals with the area of financial services. Then we have OECD guidelines for consumer protection in the context of electronic commerce, which again promotes and underlines the importance of development of ADR schemes in case of e-commerce. Then we have UNCITRAL model on international commercial arbitration, which again we need to be very careful when if we try to base any development of ADR schemes on it, because it is again a model on international commercial arbitration, not on international consumer arbitration. Again, the presumption is that in case of commercial, the parties are more or less of equal standing, of equal strength. This is why development of any model of consumer arbitration on the ground of this UNCITRAL model law is a very dangerous task. And eventually also in the area of private regulation, we have International Chamber of Commerce resolving disputes online, which has actually published and provided best practices for ODR in B2C and C2C transactions, again as one of the best models of ADR rules developed by the industry themselves, not like some kind of private regulation. About especially all of this, you can read more in the book Professor Hans Miklitz and I co-wrote on the international consumer law, which was just published by Springer. So if you want to see, you read the chapter on enforcement, so you can get more information, all the exciting about these different legal instruments. I would like, half price for you. Huh? I would like to thank you all very much for your attention, and again to thank to the organizers. I'm looking forward to the questions. Thank you.
Thank you very much. Although we are slightly behind schedule, if you have questions, we will take. Yes.
I'm always worried, Mateja, could you show us this wonderful list with all the EU requirements? Look. So it's not really what is trendy today to speak about socio-legal research or about the society. Yeah? We love to speak about efficiency, but look what happens. If you look at these criteria, it's everything what applies to a court. Yeah? So it means these ADR mechanisms are construed like quasi-minimal, slim courts. From a socio-legal perspective, this is simply nonsense. What we can learn from empirical research wherever in the world is, and you and Diana, in a way you confirmed it, yeah? You can only mediate, or whatever you call it, when you get rid of legality, when you really, when you apply psychology, when you apply whatever strategy to make people feel comfortable with the solution, but that is outside the law. When you bring the law in, you create conflicts. Yeah, that's clear. So I think the solution can only be, and I hope that we discuss this more in the 2 days, is what is the part that ADR can play, and how can you make sure that, let's say, that there is that the commonality of some legal issues is not going lost just simply because of settlement. Yeah? So you need an integrated system here. And we are, to my mind, far away from this. Yeah? Now, and you know, after after what we heard about fairness, you know, so look, fairness, after what you said, fairness obviously is a mean now just to abolish fairness, you know. Legality is a means. you can use it and argue ADR is not about legality. There is no legality, so abolish it. And what remains for the consumer? Even less. Yeah? So I think it's very tricky, these kind of things.
Yes, please.
Hi, I have a question. I'm Nick Diamond from Legal Bracer in New York. I have a question about trifle damages. So what's your perspective, although it's a big question, but what's your perspective about cases where monetary damages are not really the objective, whether there's injunctive relief or some other kind of relief? I'll give one example. Let's say privacy cases that are increasingly popular in the States and perhaps elsewhere.
Maybe I didn't hear your question very well. So can you maybe...
Sorry for everyone who has to hear it a second time. My question is, how do you react to cases where damages themselves is not really the issue? So where injunctive relief, not monetary damages, but injunctive relief may be the key objective of the litigation. And I'm giving as an example privacy cases.
Okay, I see. So that for the German legislator, that's not, so he has introduced that skimming off procedure, that disgorgement of profits scheme, but only for in the field of unfair commercial practices and in competition law. And so he did not address that kind of questions. Yes, so that's more or less. So they're not there. So like wouldn't be like personality right infringement would not be in, because you cannot skim off any profits anyway, if I understand you correctly.
So if I may, so if there were a data breach, if there were a data breach in Germany,
yes,
someone intrudes your Yahoo account in Germany or some other example, and my information has been invaded, and I'm a consumer, what rights of redress do I have?
Well, you have probably an injunction, and well, as damages, I don't know whether you could ask for.
There's a standard there.
Sorry?
Oh, in Israel you can get a standard damage.
Yeah, but in Germany we don't have that kind of standard damages for that kind of infringements. So of course, well, it's obvious that there is still, yes, so you could not use that disgorgement of profit scheme for that kind of damages, for that kind of issue, for that kind of scenarios in, under German law.
Other questions? Yes, please.
I'm Itamar from University of Barcelona, and I would like to make some comments on consumer protection because Andre, you have said that ADR is not working in terms of a good solution for these trifle damages. In Spain, we have an arbitration system that is called, it's really an arbitration as a name, but it really works more like an ombudsman scheme because it's one adjudicator who is giving a solution in a very informal process that it's paid by the public administration. You surely know that. And in that scheme, for the consumer is free of charges, and even for the enterprise, and it's not good for the system, but it's like that. And we have a kind of collective arbitration as well, that it's never, if I remember well, it's never used, but we could have the possibility of doing a collective arbitration. I'm not persuaded that arbitration is the best way of solving consumer, but ombudsman scheme, it's really a piece of the solution, as Diana was saying before. I'm persuaded of that, and the Catalan ombudsman is really very interested in that. I'm doing a report about that, and it's really working. And with my colleague, Elena Laurova from Barcelona as well, we have done a research about the insurance sector in Catalonia and in Spain. about how consumer from insurance sector can be redressed. And we have lead a group of experts of various companies, and they have pointed out very strongly that a good customer service as the first way of complaining for the consumer can be really a good idea. And only the very complicated cases and the most difficult ones should come to another ADR scheme like ombudsman or like arbitration or like whatever. So it's true that European Union is putting a lot of attention in ADR, consumer and ODR, that will be really faster and more interesting. And the point is, this mixture of ADR and collective redress should be a kind of collective ADR, should be a kind of collective ADR led by the state, because in that way, like consumer arbitration in Spain, will be public, transparent, and more likely to be in the field of EU regulation. What kind of legal hybrid should we use to bring a good solution, given your three opinions on that? If you can just say something about that. Thank you.
Let's start, or you want to start? You want to start? But maybe you were... Yes, please.
I mean, there are many good examples in member states that work in their own context. But I guess what we're looking for is something that works in an international sphere. And it's the trick to find that. And I can only talk from, in that sense, from a UK experience, but there are other models elsewhere. So the way you can put together these elements of ADR plus some sort of gateway enforcement, protect the consumers. I was going to say, Hans is absolutely correct. The European legislator is entirely schizophrenic in the way these things are approached. ADR should be something different. What you've got there is something that on the one hand tries to be ADR, is not in my view properly regulated as ADR, but then purports to be something that includes all these legal and justice principles. It's impossible. To me it's fairyland. And we need to try to move to something that's much clearer and can deliver that enforcement and investigatory element. If I had to say what my best model is, but we will all have our best model, my best model is the Danish ombudsman.
Well,
no, but we can bring up outlook.
so just no, I'm also pro ADR. So don't get me wrong. So I'm also pro ADR. The only thing I'm saying, ADR helps consumers to start earlier to fight for the rights, and I agree. Nevertheless, there are trifle damages where even if you have a good and working ADR scheme, you're just not doing it because it's so much of a hassle that you are stuck. So, for example, if you have a glass of Nutella and you're a hardcore Nutella user, it's always 10 grams too few. So even if you have eaten all your life Nutella, you're not going to ask for damages because you get 10 grams too few every glass you're buying. That is what so I think that there should be like an ADR and maybe plus a legal hybrid for things ADR and the normal other collective actions cannot cover. Okay.
I think definitely, I think that's it. I would definitely agree. So, it's very difficult to choose which model, but each of them has different advantages and disadvantages. But again, I think the models of the Scandinavian are in that sense the best. But the other one is I don't think it is the best. It's just the effective models.
Thank you very much for your questions and comments. And on behalf of all of us, I would like to thank the members of this panel for sharing their interesting ideas with us, and enjoy the rest of the day. Thank you.
רגע, מה השם עכשיו?
אחת.
נראה לי...